Registered land. Registered land in English law accounts for 88% of the total land mass. Since 1925, English land law has required that proprietary interests in land can be registered, except in cases where it is necessary to protect social or family interests that cannot be reasonably be expected to be registered. There are three fundamental operating principles of registered land. Number 1, mirror principle. The register should reflect the totality of the rights and interests concerning a title of registered land. The point is simply that if the register reflects the full character of the land, any purchaser and any third party can rest assured that they are fully protected. The purchaser knows what he is buying, and the person with an interest in the land knows that it will be protected. However, overriding interests, which are a category of rights which affect the land and which bind any purchaser without ever being entered on any register, compromise the status of the mirror principle. If you are in actual occupation and have proprietary interest by simply investing in the land, then your interest is an overriding interest. Glynn Bank V Roland described actual occupation as physical presence on land. Number 2, the curtain principle. Certain equitable interests in land should be hidden behind the curtain of a special type of trust. If a person wishes to buy registered land and that is subject to a trust of land, the purchaser needs to be concerned only with the legal title to the land, which is held by the trustees. He need not look behind the curtain of the trust or worry about the equitable rights of ownership that might exist. Any such equitable rights will be overreached by the purchase money that the trustees will get for the equitable owners. The main point is to facilitate the alienability of land by freeing the purchaser from the effort and worrying of dealing with equitable owners. Number 3, insurance principle. If a title is duly registered, it is guaranteed by the state. The state insures against inaccuracies or other mistakes in the register. For example, if A is the true freehold owner of the land, but B is registered with the title by innocent mistake, and then C buys the land from B on the basis of his registered title as guaranteed by the LRA Land Registered Act 2002, it is obvious that either A or C will suffer by reason of application of the registration system. The insurance principle stipulated that a registration system must provide compensation in such cases. Overall, the LRA 2002 has reduced the power of overriding interest in both schedules to ensure that a potential purchaser is bound only by those unregistered interests which, for practical reasons, that the purchaser had a realistic opportunity of discovering the existence of the interest by a physical inspection of the land or by making normal inquiries of the transfer. Overriding interests were a cause of concern to the Law Commission and Land Registry when devising the Land Registry Act 2002. But their social and economic importance is such that they cannot be dispensed with. However, the Land Registration Act 2002 can reduce the impact of overriding interest to reduce their number and to encourage their entry on the register. Section 71, subsection B, places an obligation on paper owner to make all interests of the land known to the subsequent purchaser. That is the only good development made for the subsequent purchaser.